I reconvene this special magistrate hearing dated March 4th, 2020, to continue the agenda for today, which is the reduction hearing schedule. For all of those who have not been sworn in but plan to give testimony today, could you please stand up and raise your right hand to be sworn in? Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth? Thank you. Please sit down.
First case, other matters, number 10, 828 30th Court, CE 15110442, 828 30th Court, number 10.
Didn't you just say you were going in order?
Of how they signed in.
And your name is, for the record?
My name is Sumner, S-U-M-N-E-R, last name K-A-Y-E, Commonwealth Investors,
And what is your relationship to Commonwealth Investors?
Vice President of Commonwealth Investors.
All right, thank you. I'm going to let the city officer, let me hear from him first, and then we'll come back to you, and you can say whatever you like.
Okay, thank you.
Thank you. Yes.
828 30th Court, case ending in 442. Date ordered 1/6 of 16, fine started 3/7 of 16, ran for 25 days, total $2,500. Was $100 a day, date of compliance 4/1 of 16. It's the same owner. Under this ownership, there have been 8 cases where it was cited. Their mitigating factors, they claim it took 25 days to fix the screens. However, they had 48 days before the hearing to comply, 60 days afterwards to comply, and the fines ran for the screens as well as roof repair, interior repairs, paint, plumbing repairs, stairwell rails missing, window and door repair, broken appliances, clean and sanitary, fence repair, and pest control. Additionally, we haven't been able to look up the entire history of all their different LLCs over the years, but we are familiar with 2 other properties, one of which is 719 52nd Street, which they had for 12 years and had 41 cases at that time, then sold it for $65,000 with over $3 million in liens that occurred under their ownership, and was managed by the city under the chronic nuisance program for 4 years. Additionally, one of the partners owns 208 34th Street, which has had 8 cases, and also currently has a lien for $197,000. City's asking for 50%.
Yes.
Well, in my defense, Madam Magistrate, first I'll try to recollect what the gentleman said, but let's first go to 828 30th Court. We were cited, properly so. We had some very rough tenants. We had 3 break-ins. Numerous times we had to call the police, but we have it straightened out. However, the house is a landmark property, and we refinanced it, and it got a very good appraised value on it because the property is impeccable. If the gentleman wanted to go inside, he could have asked and gone inside. Ray Leone has been great on this, understands what we had to accomplish in this neighborhood with this property. At the closing, when we did a refinancing of $225,000 that we got back, basically for $2,500 is the fine at this time, and we're asking for those funds back, a reasonable facsimile, because we did comply. It did take 25 days to put the screens in. We have 31 windows in this landmark property. We couldn't go to Home Depot with our people. We had to go to a individual person who really know how to fix these landmark properties. So that's part A of our defense, if you will. Secondly, he mentioned something about 208 34th Street. I'd like him to repeat that if he may, please. Or did he not mention that?
I did. Do you want to repeat it?
Yes, if you could repeat it, sir.
What I said is one of the partners owns 208 34th Street, which had 8 cases under that ownership, including a current lien for $197,000.
So I'd like to address that. There is no current lien on it. There never was. I don't know where he got the information from. There was a fence, a gate in the front was put up properly with the permit. The gentleman did the gate on the front, did not pull a permit for the back, true and correct. Code came by and wrote that situation off. He said you were totally in compliance. And that was on 208 34th Street. I'm not sure where he's getting this lien stuff from. Then there was another complaint. Are those the only two complaints, sir? I'm sorry, to talk to you. Those are the only two issues he's mentioned, or was there another one?
We mentioned 719 52nd Street, but the information just given on 28 34th Street is absolutely false. There is a $197,000 lien, and this gentleman submitted a lien reduction application, which has not made it to a hearing yet.
Okay.
We never put a lien reduction in on 28 34th Street, sir. It was just for the back fence. So you better cite chapter and verse of that one.
Well, sir, obviously the city records show that you have, so that's a different matter from what's
Yeah, I
before me
understand.
today.
I understand.
So I would suggest you get in touch with your code enforcement officer and get that part straightened out, because if there is an existing lien on that other property, the partner or the right who owns that property needs to step up to the plate and get everything resolved, because obviously, according to the city's records, there is a sizable lien on that property that needs to be addressed by your company
I
or
understand
your
what you're
partner.
saying. I
But
follow
that's
that.
not for today. So let's
Okay.
just deal with this
Okay.
property today.
So let's deal with it. So that was the issue on the screen windows on that property. The 719, if I may just 1 second, on the 719,
No, let's leave that one alone for right now.
you brought it up for discussion, ma'am.
Then go ahead.
It's not hearsay, it's pragmatic, I'm here.
No,
So-
no, there's no hearsay. Nobody said there was hearsay. So
Well-
go ahead and say what you want.
719 had 3 murders. We closed the property down. There was prostitution. I've called the police numerous times. They did come out. There was fentanyl on the street, drugs on the street constantly. My guys didn't want to go there any longer because of the murders on 52nd Street and 53rd Street. You can understand why they didn't want to go back to those properties. We sold the property to pay the fines and the taxes, which we gave to the city $22,000 or more based on, or I think 60,000, I believe it was, that we paid off debt. But he's painting a picture that we're not good landlords, we're great landlords. And if murders occur on your property, you have to board up the place and walk away from it, or you're going to have a problem with your own life. So that's enough on 52nd Street. But the way it's portrayed was not correct, ma'am. But going back to 828, which is the issue today, that is the windows that took 25 days, $100 a day. There was some painting on there. And we did have some break-ins, and we did have some arrests. And we did have people throwing stuff down the toilets and clogging them up. It was a bad situation. We tried to give some Section 8 people a break. It didn't work out. So it wasn't like we didn't put stops on that situation. Actually, we got harmed by that situation. And you'll see on the 18th, when we come back, there's another property that's infested with rodents that we've been fighting for 2 years already. But then I'll end my defense on that, but he did bring it up, ma'am.
And how much were your cost of correcting the violation of the screens?
For the
The screens, the cost?
screens cost us close to $4,500.
Okay, is there anything else?
Just to sum up that, according to city code, the ownership history within the city, period, not just that property, is a relevant factor for lien reductions, and there was no picture painting. We just simply presented the facts of those 3 properties. In addition, a requirement to rent a property in the first place is having those screens. And that was just one of 12 different violations in this particular case.
May I address what he just said?
Half of $2,500 does not seem a big ask for the city to ask.
May I address that?
Yes, well, hold on.
I guess the
Let me
gentleman's
make-
not.
Hold on,
please,
let me make sure he.
The gentleman's not listening. We told him we had 3 break-ins. Those break-ins were done by vandals on those screen windows. Sir, would you make him please listen?
I've heard every word he said.
I am listening,
Okay,
and it's
fine.
me who needs to be listening. Quite frankly, what he is doing is that he is giving his counsel paperwork about this case. So he is not interrupting you, so you can just talk to me.
Right, okay, well, I always heard that the First Amendment, you have a right to address your accuser. That's what I was doing. Thank you. So on the screen windows, going back to that again, That was done by abuse of people who lived in that area or came into that area. And therefore, we're requesting $2,500 back from the escrow account that's in the title company.
Okay.
Thank you.
Anything else you would like to tell me?
No, ma'am, thank you.
Okay. And how many days were you asking?
I'm sorry?
How many days was the city recommending for payment?
Oh, we don't normally make a recommendation. Generally, we're pretty willing to go with how long they say they need, as long as it's reasonable.
Okay, I'm not going to reduce it down to the 50%. I'm going to go a little bit beyond that. I'm going to do a reduction down to 25%, which is $625. How long do you need to pay it? 30 days?
$625
Yes, 30 days?
on the $2,500?
No, we're reducing the $2,500 fine down to $625.
Understand, what's going to happen to the $2,500? That's getting reduced to $625?
That's being reduced to $625, which is 25% of the total fine. Can you pay that within 30 days?
Absolutely.
Okay. Okay.
I got hurt in Vietnam. I can't walk over there. When I was 28. Thank you. Thank you very much.
Next case, other matters, number 4, 506 53rd Street, CE 181101158, number 4, 506 53rd Street.
Yes. Can you state your name for the record, please?
Bemnet Johannes on behalf of Masai Kafle.
Okay, if you can just wait, we're going to hear from the city first, and then we'll come back to you.
Okay.
Yes.
She's familiar with the setting. Case ending in 158, 506 53rd Street, date ordered 1/16 of 19, fine started 2/15 of 19. Ran for 88 days, total $8,800, daily fine of $100 a day, date of compliance 5/14 of 19. This is the same owner, property's been cited 5 times under the same ownership. Our understanding is Ms. Bennett, the property manager, basically lives next door. The mitigating factor on the application is they didn't receive the notice, but that was because they didn't change their address with the property appraiser. So it was sent to the correct place and has now been changed to 522 53rd Street, which is 2 houses away. Fines ran for trash and debris, fence repair, outdoor storage, overgrowth, and a permit needed for shutters that were installed. City's asking for 50%.
Yes.
Yes, the problem with that property was the fence, the fencing metal that was there was broken, and the tenant never, alerted the owner in order to let them know that there was a siding. And that siding was not going, did not receive any kind of mail or notice toward the 522 53rd Street, where it was going to the same property where the tenant is residing, all the mails. It should have been to 522 53rd Street, which probably took time for the address to transfer. So because of that, it was accumulating, and it was just a random check of property that he was able to find what the issue was, and then contacted the code enforcement, and it was fixed like within a couple of days. So we're just asking if it can be into administrative fee. That's the only property that person owns, Kafle owns for that house.
Okay. Do you have anything else, Hoff?
No, sir. No additional no, ma'am. No additional information.
No problem. And do you have anything else you want to add?
No, just asking the city if they can go down to administrative. It's just as far as fixing and whenever something is aware, even in my property, if there is something, I fix very quickly, and I have such a high interest on this property down the line, so, which is why I'm representing the owner. So
Okay.
I want everything to be cleared before I pursue that.
And how long has this been rental property?
I'm sorry?
How long has this been rental
The
property?
tenant has been there, I think it's probably 5 years, I'm not sure. But it used to be, that whole block used to be a very bad block of all kind of prostitution, and it's cleaned up pretty well over time.
Okay, this is what we're going to do. Unfortunately, it sounds like the city did give you proper notice, and because that was the notice that was in the public records at the time. I understand that you guys have changed your notice and addresses so that it is at the correct address.
Yeah, that was done probably like around the time, I'm not sure exactly.
Yeah, so just
what
make
day.
sure, so you don't end up in that situation again. Just make sure, a friendly word of warning, just make sure that you always keep an updated address on the public
Sure.
records, the property appraiser and the tax collector records, so that you actually get your mail and you're not relying on your tenants to
Oh, no.
not throw it away and get it to you on time.
Plus, it takes time, I believe, for it to register on PAPA, from my understanding. So it was just a random check. It wasn't even because we were aware of it. It was just, I guess, he was just checking through to see if there was anything before.
Okay, what I'm going to do is, I'm not going to go with the city's recommendation of reducing it just 50%. I'm going to reduce it down to 25%, which is $2,200. How much time do you need to pay?
Today.
To pay? You'll pay today?
Sure,
So we'll give you 30 days,
no problem.
okay?
Next case, other matters, number 1707 Village Boulevard, number 205, CE 151-00431, number 7.
Hi, and your name for the record?
Good morning, Florence Turgi, and I am the property manager.
Okay. We're going to let the city speak first, and then we'll come back to you.
Thank you.
Thank you. Yes.
Case ending in 431, 1707 Village Boulevard, Unit 205. Date ordered 12/2 of 15, fine started 1/4 of 16. Ran for 1,360 days. Total is $136,000. It was $100 a day. Date of compliance, 9/25 of 19. This is the same owner. No mitigating factor was actually given on the application. The fine ran for work without permits. They installed an AC, but property managers experienced in the city know they need permits for those kind of things. And the permit wasn't even applied for until after the lien reduction application was submitted. The city's asking for 30%.
The city is asking for what? How much is the city asking for?
The city's asking for 30% instead of the 50% as it's such a high lien.
Okay. Thank you. Yes, and what would you like to tell me today?
First of all, I would like to tell you, the beginning of the property. So KPL, which is like a real estate broker and a property management company, purchased this unit in 2012, and after sold it 1 month after to one of their clients, Floriac LLC. And Floriac LLC sold it to Floriac USA in the same year. Floriac LLC sold it to my client in 2015. During that time, KPL, who was the original owner, kept the management, of this property. In the middle of August 2015, Mr. Moser, Harold Moser from the city, was talking to KPL on the daily basis because there are so many property in West Palm Beach, and they kind of know each other, and they inspect this property prior my client bought it, and they let KPL know, because when I talked to Mr. Moser over the phone, he told me that KPL was aware of the violation and he gave them time to fix the issue, and they never did. So they were aware before my client bought the property. So the thing is, there was a violation recorded after, my client bought the property, and the case was closed and replaced by another case in the beginning of December, because the inspector realized it was not the same owner anymore, because the first one was recorded under Floriac LLC and not my clients. The thing is, on top of that, I know it's bad. At the end of December, my client and 40 other property, they switched management company to me, and we had like this bulk of property to take care, and we asked KPL to disclose any facts, any problem with those property, and they didn't, I guess they were not happy to lose all those business, and I personally contacted my assistant, like the tax officer at the city. We work with Monique like all the time, and we were so focused on the business license, to be in compliance and everything, and the reinspection for all those property, it was a lot at the same time, This one we were never aware there was a problem with it, never, until last year. Now I think it's the new rules, the same owner or the same, even if this owner has only one property. But the thing is like member manage, because it's managed by under the same LLC. I guess the city considers the same person. So they say, okay, all your property has to be in compliance. Say, yeah, okay, for sure. And this one we found out there was a lien. I almost fainted like when I saw the amount and what it is. And so we took care of it like right away. And we were like, I disagree with the gentleman when he say like the lien, it was in compliance after the lien reduction, because with Monique, I sent her a few times, like Lydia sent her a few times the lien reduction application, but I don't know, was not processed or like not yet. And I guess really, truly it was processed after, but we sent it like a few times, so it was in compliance before the lien reduction. So what I ask you, please, Your Honor, it's like to be fair. It's going to be the last time you see me here because I want to be in compliance with all my property. But this, I really feel my client and we inherited the problem, because we will have like an AC change, like we didn't do any work like on the property. And I'm, like he said, I'm well aware we have to pull a permit and we have to do like things in order to comply, but it was not the case. We didn't change the AC unit. We didn't do it. So what I would love to, it's like just be assessed like a reasonable fee, the court fee, the whatever. I know the amount is huge. But I know it's right now the lien amount, it's like higher than the value of the property.
Okay. Once you realized that there was a violation, how long did it take you to correct it?
We took care of it right away.
I'm sorry?
We took care of it right away.
So what is right away?
Like, it was what, Lydia? We contact the AC company, and we ask him to pull up the permit and to schedule the inspection. I think it was like, the same week or so, first we had the time to digest, and say, what's going on. So I even asked the title company to look into the closing affidavit, and in the closing affidavit, it states, normally the buyer, sworn, there is no violation, no municipal, fees to pay, he's in compliance with everything. And we were thinking to ask the title insurance to take care of that, because my client cannot really afford it. But the title insurance answered us, but there is a glitch, because it was really recorded just right after you had the ownership, my client had the ownership.
Okay,
So
thank you. Is there anything else you would like to add?
First, for a point of clarification, when did you take over management of the property?
at the end of 2015, December 2015.
Okay, first to correct a few of the dates that were given. The original case was cited September of 2015 and was closed in October of the same year when the city learned that it was under new ownership. That's when their client was cited. The fine itself was ordered under on 1/4 of 16, which means the entire time it ran was actually under their management. City's position is any property manager taking over a property would do their due diligence, find out there's an open case. The short version of the entire story is two different property management companies dropped the ball for the various owners, not the city's responsibility, it's the owner's responsibility.
Okay. Is there anything else you would like to add?
No, I know it looked that way, but truly, okay, technically on the contract, it was December 31st, for the switch of management company, but when you have 40 property, it didn't happen overnight. And we asked them, begged them to have, the paperwork, and it was released, little by little through January, and as they didn't forward it, to us, the proper documentation, the citation or, anything else.
Based on what I've heard from both sides today, I am going to do a reduction. I'm going to do quite a bit more than the 30% that you're requesting. I'm going to reduce it down to $6,800.
Okay.
And how many days?
60 days.
60 days to
possible?
pay?
Thank you, Your Honor.
I'm sorry, I didn't hear how many days?
60.
60.
And you can pick up your order here.
Okay, next case. Number 1, other matters, 1331 Longwood Street, CE 180301999. Did you want to call them all together?
I'd like to do okay, hang on. The two older ones together at first, and then the one from 2018 last.
Okay.
Okay. It'll be fine to call everything together, but let's go a little bit slower because I think for the orders, I'm going to have to break everything down to each case by case, okay?
So you want to do the older ones? Okay, so number 8, 1331 Longwood, CE 09110048, and number 9, CE 11010022. So number 1, 8, and 9 for 1331 Longwood.
Okay, so you want me to present all three at once? Is that what you're saying?
No, we're just going to take them in the order that you want. You want to do the older two first?
Together, yes, if we can.
Together, yes, and that's agenda items 8 and 9.
Okay.
Okay, and your name is?
Philip Lipman.
Phil
Philip Lipman.
Whitman, okay. All right, thank you. We're going to talk to the code
Okay,
enforcement
sure.
officer first, and then we'll come back to you.
Fine.
And you understand we're going to deal with the two older cases?
Yeah, I
at
understood
this
it
property?
completely.
Okay,
It
perfect.
took him a little while, but I understood.
Okay, thank you so much.
Case ending in 048-1331 Longwood, date ordered 1/6 of 10, fine started 2/8 of 10, ran for 1,212 days. Total is $121,200, $100 a day, date of compliance 6/4 of 13. No mitigation given on the older case, but this is a new owner that did not originally cause the violation. Case ending in 022-1331 Longwood Street. Date ordered 3/2 of 11, fine started 4/5 of 11, ran for 591 days. Total $59,100. $100 a day. Date of compliance 11/16 of 2012. Also no owner, but no mitigation given. The city's asking for only 10% on these two based on the size of the liens and the fact that they didn't cause the violation.
Okay,
Okay,
thank you.
I mean, I represent the owner, first off. We had no, as far as I know, the owner had no, didn't have any idea about these two liens when she purchased the house. So when we got the, when she got the phone call, it was pretty shocking. So I advised her to call the Eni Jackson, which is the title company lady. And so we called her up, and she called us back within the hour. All this happened within 1 hour about a week ago. And she called us back within the hour, and she said that she would email us paperwork stating that she talked to your lawyers within the city, and the city said that it was fine. And I have her handwriting saying that there was no issues, and maybe that's why Eni Jackson never told the owner that there was liens, because the attorneys there said, I'm not sure, wait, let me see, the attorney, Chris something or other, said that the previous owner, I can't really read the thing, but it says the legal department, Erica Leading, I guess, was the person who told her. But anyway, someone told her, so I guess she wrote it down on a piece of paper. This is the first that the owners heard of it. This is the first that I've heard of it. The title company lady heard about it apparently on 5/2016, which is before, of course, the purchase of the house was made. We got the all clear, and she asked me to come down to check the place out. I did. I didn't know anything about houses at that time, so I said, it's a house, buy it. And that's what happened. Then 4 years later, we get a phone call, and this is what we got. So we're asking to get reduced down to 0.
Okay. Is there anything you would like to add, sir?
I can't think of many times when the city would agree to reduce something to 0. I thought 10% was rather generous.
Okay, and let me ask you, sir, Mr. Whitten.
Yeah. By the way, we heard something like in the area of, he said a lot of words, so I'm not sure what the numbers were, but we heard in the area of like $200,000 or something. To get something like that, a number thrown at you, or $200,000 that you owe that you had no idea about, that's going to cause a lot of anxiety. The owner has anxiety right now, is taking medication for it. Not related to this, but trust me, that did not help it at all. It did not help the situation at all. Just to be, I feel like it's pretty apparent that if the owner doesn't know about something, if she pays the title company X amount of dollars plus $50,000, which she just threw to the title company person, she was trusting the title company person at that point, since she doesn't know anything about real estate, to just handle $50,000. This is just trust, just pure trust. Then many years later, we get this news. It's not something that we knew about. If you don't know about something, you can't respond to it.
Okay, let me ask you, since you're the new owners, did you have to correct these violations, or were there just outstanding fines at the time of purchase?
Why don't I show you the piece of paper? Because like I said, since I don't know anything about this, I'll just show you the piece of paper that she emailed to me and submitted as evidence, because I think that's better. It actually says something. It says, per city's attorney, this remains with previous owner, but not the property. Per legal department, Erica Leading, City of West Palm Beach Legal Department, there's a number 822-2212. I just got this piece of paper, and I'd like to submit as evidence.
Okay, that'll be fine.
I know recordings are not allowed, but of course I recorded Eni Jackson saying that we were not responsible for it. She's an honest woman, and she truly believes that we're not responsible for it. I have that as evidence too, if it's allowed, if cell phone recordings are allowed. I don't know if they are.
Okay. Well, she's not here today to say that, so,
I have her voice saying it on a cell phone, but,
yeah,
you know.
right now.
If you'd like that, I have that as evidence. Of course I took that, because
But-
once I heard $200,000, you know, of course I recorded the conversation saying that we had no idea about it.
Okay, let me
Ma'am,
look at the
can I-
piece of paper. Let me look at the piece of paper. And I also recognize that that is hearsay testimony. So
That wasn't
that's,
what I was.
I understand.
If I may, ma'am, what I was going to request is that we pull this from today's hearing.
I would rather not pull it. I'd rather settle this matter, because why should the owner have $200,000 on her head for something that she had no idea about? So please don't pull it. Please, let's settle it.
Okay.
Bottom line is, this is not information we had. We know they just found out about it, but the city did offer to let them go a different
The
date. so
city
they'd have
told
more
us
time
just
to
last
look
week
into-
they called
Hold
us.
on, sir. You have to, we're going to let each one of you have your say.
Okay.
And please do not, both of you do not interrupt the other. We're going to be very civil here. It does not warrant talking over each other, and I am not going to allow that to happen. So you will get another chance to speak and say what you
Thank
need
you.
to speak, but you need to let everybody else have
I
their
didn't know.
say too.
Thank you.
Thank you.
Rather than surprise the owner with two liens that we weren't sure they were aware of, we reached out to them Monday and said, hey, I don't know if you're aware of these. We can pull this or not go this week if you'd like to. But a request to wipe out the entire thing based on information they had that the city wasn't even made aware of, we'd like to pull this and have a chance to look into this. If he's correct on that information, that would wipe out the lien and he wouldn't even need to be heard on it. And you wouldn't need to rule on it.
Sir,
If
that's what
if
he's
he's
saying, and you're
suggesting-
hearing say that, I think it might be to you and
I
your
understand. If
friends'
he's
benefit
suggesting that to pull it is to investigate it, and to look at the handwriting and to call up Eni Jackson yourself, that's fine. Because
So
Eni's a
I
wonderful
think
lady.
It would
You
be
know, that's
much
fine.
better
If
to
that's,
pull
if
it.
you feel like that's what you'd like to do. I would come back. I don't mind flying back here. You know, I came in for one day for this. I'll come in another one day for this. It's not a problem. So let's pull it.
It sounds like it might be to your best benefit, so
Thank you.
I think what we'll do is that we will reschedule this for another hearing date to be determined once the city has a chance to, look at the information that you've provided today, and then you'll be contacted about the new hearing date.
Thank you.
Thank you.
Next case.
Thanks, what they need.
Number 11, 4311 West Terrace Drive, CE 17060.
Oh, excuse me. I thought you were just pulling I understood before we're pulling 8 and 9, not 1. I'm here for something else.
All would have to be heard at the same time. It's the
Why?
same-
They're
Because it's the
separate
same
issues.
property and that's the city code requirement.
Yes.
All
we're
liens
gonna-
would have to be heard at the same time. That's the city code requirement.
And it's probably going to be to your benefit, and that's what we're going to do. We're going to continue all of these hearings and reschedule them for another date. The city can look at the information and.
See, at this point now I have to reapply for, if this gets pulled, then I have to reapply for a lien reduction because it gets expired on March 13th. So if you
I
pull it now, then we have to go through the whole
I believe if
process.
we
I have to
pull
talk
it
to
on
Monique.
our request, legal will advise we can extend that date. We're not going to require another application.
Okay. Madam City Attorney?
Correct. If it's our request to continue the matter or otherwise pull it for a later date, it would almost stay or toll, for lack of a better word.
Additionally, since the time of their application, city code was changed, there's no longer an expiration date. There was only on theirs because it predated the code change. So
Okay.
either
Okay.
way, we will not require a new application.
Okay, thank you.
Sir, they will not be putting you in jeopardy by rescheduling this. Give them the opportunity to look at it, see what's going on, and we'll reschedule the hearing. Basically, we'll just continue it until a further date. And it's told or stayed that the city waives and tolls any new application needed for these 3 specific cases for the reduction of lien hearings.
Okay, thank you very much.
You're welcome.
Okay, back to number 11, 4311 West Terrace Drive, CE 17060460. Number 11, 4311 West Terrace.
Okay. And your name for the record?
Mary Marlowe.
Hi, Mary.
Hi.
Mary, we're going to hear from the code officer first, and then we'll come back and you can tell me whatever you want to tell me.
Case ending in 460, 4311 West Terrace, date ordered 7/19/17, fine started 8/19 of 17. It ran for 828 days. Total is $82,800. Daily fine was $100 a day. Date of compliance 11/25 of 19. This is the same owner. 12 cases under this ownership, the last of which was just 2 months ago. The fines ran for boat screening, boat parked on the grass, junk vehicle. Additionally, was cited for shutters without a permit and a boarding certificate, but that was complied by the compliance date. The only mitigating factor is I didn't know about the other violations. City's asking for 50%. And apologies to the magistrate, I have the wrong Papa sheets. I have 4311 North Terrace, so I don't have it to give you.
Okay. Yes, Ms. Marlowe, what would you like to say?
Okay, I understand there has been some violations. However, whenever I was issued a violation, I tried to take care of that in a timely fashion. As for the boat, it's actually on the drive. And we were told that it had to be covered by 3 sides. What we have, it is covered by 3 sides. There's my house to the east, another house to the west, and one to the south. The grass, I went to great expense to replace the grass.
It looks nice.
Excuse me?
We have pictures. It looks nice.
Thank
The
you.
grass looks good.
I was told that I needed to paint it. I did that within a time period. The problem was that I didn't know I should call the city each time I took care of whatever had to be taken care of. I wasn't aware that I had to call the city and let them know this had been taken care of. So I didn't know I was accumulating these fines until the last code inspector alerted me to the fact that I had a lien, and I couldn't understand why. Because I was taking care of whatever I was told needed to be taken care of in a timely fashion. And I had no intentions of trying to lose my property. I took my savings to pay that property off. So I'm retired. I wouldn't have, a mortgage. I would only have to pay, worry about insurance and maintenance and this sort of thing.
Is this your home or is this rental property?
It's my home.
Okay.
And I'm truly asking for leniency here because I've tried to abide by everything. I've put my savings into this. And each thing I was given to do, I tried to do it. Well, I did do it, and sometimes at great expense, because I had the yard dug up.
Yep. How
which
much
was a
money did you
great-
have to put in to fix everything?
Excuse
How
me?
much money did you spend fixing everything?
To do the yard, I spent over $10,000 because I had to have it dug up, re-sodded.
Okay,
I pressure washed the drive. That was close to $500. In order to paint the house, that cost me about $1,500, including the paint. The shutters I did remove from the house.
okay.
And right now, the lien is more than the value of my house.
Okay, all right. I understand what you're saying. Sir, do you have anything else to add?
Yeah, the city has no reason to dispute how much she spent, of course, and no reason to dispute that it was in compliance, and she just didn't know to tell us. We just know it was not in compliance by the comply date, because that's when the city would check those things. Other than that, pressure washing, painting, and replacing the grass wasn't actually part of this case. It was probably referring to one of the other 12 cases.
Okay,
That's it.
all right. Well, your property looks nice, especially the sod, and it is your home. What I'm going to do is, I'm going to reduce the fine to $1,500. And how long do you need to pay it?
Can you give me 60 days for
We sure
that?
can.
Can the city request that be 90? We want to make sure she has the chance to do that.
Okay, the city is saying that perhaps we should consider giving you 90 days, 3 months to pay it, just to make sure that you pay it, because if you don't pay it within the time frame, the fine goes back to the original amount, which would be the $82,800.
Thank you.
So we want to make sure you get that $1,500 paid, so we'll give you 90 days to pay it.
Thank you.
Case number 5, other matters, 932 31st Street, CE 17090110. Number 5, 932 31st Street.
Good morning. If you could state your name for the record,
Good morning, Adriana Clemens on behalf of the owner.
and how are you related to?
We are the attorneys representing the current owner, 932 31st Street Trust.
Yes, and your last name again is?
Clemens,
Clemens. Thank you so much.
no problem.
We're going to have the city speak first, and then we'll come back to you. Yes.
Case ending in 110, 932 31st Street, date ordered 11/1 of 17. Fine started 12/1 of 17, ran for 360 days. Total $36,000. Daily fine was $100 a day. Date of compliance 11/26 of 18. This is a new owner, which is the only mitigating factor on the application, that they were not the ones to cause it. But the application itself was delayed in getting to a hearing because it took the current owner 6 months to get an action plan in place for the chronic nuisance case where the city was managing the property for them. The original citations were for roof repair, bare landscape, trash can, and white goods storage. They purchased the property for $71,000, currently appraised at $115,000. City's asking for 30%.
Yes, miss.
So our position is very simple here. The violations occurred back in 2017 under the watch of the previous owner of the property. The current owner acquired the property through a lender foreclosure action. Under the authority of Over versus Town of Lauderdale by the Sea, which is a 4th DCA 2017 case, which is controlling and binding in this jurisdiction, all of these liens have been extinguished by virtue of the foreclosure sale. In this case, in no uncertain terms, expressly holds that any liens, whether they were recorded or not, prior or after the entry of the judgment of foreclosure are
And the city
extinguished.
objects. This was not on the application. They didn't include this information. We're pulling this to further discuss the issue.
Okay, hold on. Did you understand, the city said they had no knowledge of this, it wasn't part of your application, so they would like to continue the hearing to another date in the future so that you can provide that information to them, because it was not included in the original application.
Had it been in the application, we would have researched it, and if she's correct, not even had a hearing.
I was not the one filing the application. However, I understand the city's position, even though it was rude to interrupt me while I was speaking, since I did not do that to you. Having said that, I understand, and we don't have an issue with that.
You don't have any issue, that's fine with you?
We don't have an issue pulling the case if, after considering this case, which I can provide to the city right now, the violations go back to 0, because the other alternative that we would have would be to file a quiet title action and seek sanctions against the city under 57-105 for supporting or defending a claim that is not based on existing law.
All right, thank you. If you can bring the case up here, we'll
For
put it
sure.
as part of the court hearing
So I
up
don't-
to
I'm-
this point, since,
Sure.
and thank you, Ms. Clemens. Okay, I actually see the Assistant City Attorney at the podium. I'm assuming you would like to have something on the record, so please, what do you need to tell us?
I just want to make sure that we clarify the reason that we're pulling it for today is to review what you've submitted, to then review the entire case to make sure what you're saying is correct. It doesn't mean, I want to make sure that you understand we're not pulling it and the lien goes down to 0. That's not what we're saying, and I'm not sure if that's what you said. I just want to clarify,
Well,
that's all.
then if that is the case, given that my client is already paying for my time of being here, and this is a three-page case, then why don't we recall this case after the remaining claims here are heard, so that I don't have to come back if that is the case?
Ma'am, the application clearly states what is the reason for this reduction request. They failed to adequately fill that out. That's on them. If she has to come back, her client can pay her.
All right, I think that what I'm going to do is go ahead and continue the hearing, because, let me tell you, Ms. Clemens, it's not just reading this case. They're going to have to go back. They need to ascertain if they actually got notice of the foreclosure hearing, and what their position was in the foreclosure hearing, if they were one of the parties. Normally, all lien holders become part of foreclosure hearings, so that they know whether they're closed out or not. And I think, quite frankly, that it will serve everybody's best interest to have all the facts in front of them, and it might work out to your benefit.
Okay, and just so that the record is clear, and I understand your ruling about continuance, they did not appear at the foreclosure action, even though the lease pendants was recorded back in 2017.
Thank you.
If you have a
That'll be
business card to leave with me,
Yes.
we can be in contact.
Yes, and if you need to discuss any further, the hearing is continued at this point, and you can discuss this in the next few minutes
In the future.
away from the hearing time.
Okay, no
Thank
problem.
you so much, Ms.
Thank
Clemens.
you.
I appreciate your patience and consideration and courtesy.
Thank you.
Number 2, other matters, 715 41st Street, CE 18050057. Number 2, other matters, 715 41st Street.
Good afternoon.
Afternoon.
And your name for the record?
Ivan Navarrete.
Ivor?
Ivan, I-V-A-N.
Uh-huh.
Last name is Navarrete, Navarrete.
Okay. We're going to have the city present their facts first, and then we'll come back and you can let me know whatever you need to let me know. Thank you. Okay?
Case ending in 057, 715 41st Street. Date ordered 6/6 of 18, fine started 7/10 of 18, ran for 41 days, total $6,150, was $150 a day. Date of compliance 8/20 of 18. Same owner, mitigating factor given is forgot to change the Papa address, so it did not go to them. But in 3 years of ownership, they've already been cited 6 times, so the city's basically assisting and helping to manage the property. For this case, it was cited for safe egress, paint, unpaved parking, outdoor storage, trash can and view, fence repair, trash and debris, fine for the paint and fence repair. City's asking for 50%.
Okay, and what were the, for the safe egress, that's one of my concerns. It says removing panels from windows. What was on the windows?
It was the windows, they were shuttered at the time of the case, and it's a rental property. You can't just keep the shutters up. You have to allow for them to
Okay.
have egress.
Yeah, the main thing was we didn't receive the notice, so that's what it takes so long to approach. But once we got the information from, we called for another thing, and Mr. Michael and Ms. Monique were very nice and let us know there was something else. So we fixed it within the 8 days. After 80 days, we didn't even know. And then we realized that we had to change the address to our home, and instead of the tenant to let us know what happened. Obviously, they disappeared the note, and we didn't know about it. But we fixed it within the days. Then we asked for inspection, but it was a hurricane time, and the shutters is still up. And then they find out the screens was broken or something. We replaced those screens within 15 days.
Mm-hmm.
And we asked for the inspection again, and everything went fine. And I'm asking for the reduction, just because we didn't know it was going into fees and extra stuff.
Okay. Do you have anything to add?
Yeah, we're sure they didn't get it. The address issue was their responsibility, though, and again, cited 6 times in 3 years. So that's their history, city asking for 50%.
Okay, and how long have you owned the property?
I believe, I don't recall exactly, but 2015.
2015, okay.
December 2015, ma'am.
And what was the city's request for a reduction?
50%?
50%, okay. Okay, I am going to order a reduction, and it's not going to be at the 50%, but I'm going to have it reduced to 2,000.
2000. I mean, since I didn't know about it, I think it's kind of high still. The other violation that he's mentioning, one of them was because the roof, we didn't pull a permit, but it was nothing major, under $1,000 fixed. And the inspector went out, and I don't know, it was a city problem. They didn't turn it in, and it keeps going. So there's basically no violation that I've been having other than this one, of course.
Yeah.
It's my fault.
Yeah.
But I don't see being my fault. Every time I got a violation, I take care of it right away. And the other violation that he's pulling up from before, it was basically I take care of it right away, and it was not my fault. It was
Yeah.
just.
Why he introduced that evidence is part of the city's ordinances about what I have to consider for
Okay.
lien reduction.
All right.
Is how many cases does the city have with the same owner or at the same property to weigh
All right.
everything.
No, I understand
Now, the
now.
city's asking for just a 50%. So I'm giving you a third, a 66, a 2/3 reduction in the fine, not just 50. So, but you are a rental property owner. You are in the business of renting this property and maintaining
I
it.
understand, I understand.
And you know, if you've had other citations, you know that you need to keep your business address for your business mail current so that you get proper notices from all government agencies.
Sure,
So,
I understand.
what I would recommend in the future, it sounds like you do, once you find out about it, you do jump on the matter and sort it out and get it taken care of. You really just need to have good business practices and keeping up the best address for you and your business at the public records, whether it's at POP or the tax collector, because you don't want to miss your tax bills too.
No, I understand, thank you.
So I am going to reduce it down to 2,000. How many days do you need to pay? It's 30 or 60?
30 days is all right.
Are you sure?
Sure.
Because remember, if you go past the 30 days, it's going to go back to the original amount, which is the 6150.
No, I will pay now if
Okay.
I can, thank you.
That's it? We have an order for you?
All right.
Next case, number 6, other matters, 510 44th Street, CE 19070407, number 6, 510 44th Street.
Hello, your name for the record?
Michael Panzak, here regarding 510 44th Street.
And your last name again? I'm sorry, I'm
Michael Panzak.
Panza. And your relationship to the property owner?
Was the property owner up till January.
Okay, thank you. We're going to hear from the city first, and then we'll
Yes,
come
ma'am.
back and you can say whatever you'd like to tell me.
Sorry, I misspoke. Up until December, this past December.
Okay, I understand. Yes.
Case ending in 407, 510 44th Street, date ordered 8/7 of 19, fine started 8/23 of 19. Ran for 60 days, total $6,000, $100 a day, date of compliance 10/22 of 19. The applicant is the prior owner, was the violator originally causing the lien. Under his ownership, there have been 13 different times it was cited. It was sold for $155,000 in December. Mitigating factor is they complied it, but the fact is they complied some of it, and when the inspector went back out, there were still violations. I have those pictures if they're needed. You basically can't remove trash and debris and replace it with other trash and debris and it be in compliance. City's asking for 30%.
Thank you. Mr. Panza?
Yes, ma'am. Let me first start off by saying that both Mr. Posner and Mr. Thompson have been complete gentlemen and trying to help me, assist me in getting this situation resolved. I've owned the property for 15 years. I was not aware of the fact that I had 13 prior. If they were probably garbage in my front yard. The property has a driveway in the front of it where people feel the need to just take their trash and throw it there on any given day, which we'll get into as I kind of walk you through the steps of what happened. But in August 7th of 2019, I was called into a hearing, not before Your Honor here today, but before another gentleman, and he had given me I told him I just needed a week. It was literally a chair on the side of a house and a garbage receptacle that was in plain sight from the street. I went back out there. I'm sorry, there was also a washer and dryer that were visible from the street. They asked me to screen that. So I went out there, I screened the washer and dryer, I took the chair, got rid of the garbage that was in front of the house, and moved the garbage receptacle around the back of the house. Those original violations were cleaned up. Officer Thompson went back out on the property on August 23rd to re-inspect and observe the violations. When he was out there, he saw a laundry basket laying on the ground in front of the washer and dryer, because the lady of the house who was my tenant at the time, was doing her laundry and had left her laundry basket on the side of the house. And then there was a piece of leftover material from blocking the material that the city had asked me to do, leaning up against the side of the house. We complied with the original violations. I'm not sure how many bites at the apple the city wants, when you go out and you say, we need you to do A, B, C, and D, and then you go out there and say, well, you did A, B, C, and D, but now we see E, F, G, and H. I don't know how that jives. And then, so subsequent to that, the city went back and retrospectively started finding me from the original sightings, which were already cleared up via the pictures, and I'm sure Mr. Posner has those. And so, I mean, if I complied to A, B, C, D, and E, and you go back there and you see E, F, G, and H, and they're completely different violations, I'm not sure how you go back 30 days prior to and start the clock on me and give me a 60-day, $100 a day violation. That's where I'm at. I've got 60 days at $100 a day. I've done everything they've asked me to do. I paid my $200 application fee on December 23rd of 2019. It took 72 days to get back here. 72 days for me to get back here to you, ma'am. I'm not sure how that's kind of any kind of governmental efficiency, but I'm not here to comment on that. I'm just saying, you know, I came here, I closed on the property, I did everything that was asked of me, and I'm asking for a zero reduction.
Okay.
Okay, first of all, at any given time, the city has over 400 lien reduction applications. Every application states right on it. It will take up to 90 days to get to a hearing. So I'm glad we took 72 days and not 120, which can happen if there are complications. Fortunately, there weren't really that many complications in this case. Second of all, the magistrate's order on August 7th was 15 days or $100 a day. 15 days later brings him to his reinspection date of August 23rd. Here are the pictures from August 23rd. You can clearly see that even if he picked up trash, there's certainly trash there.
But it's a different pile of trash, sir, and I have those pictures as well. So I can't stand guard in front of my house, and if you see one pile of trash, you'll see that there's another pile of trash. If you'd like to go back to the two sets of pictures, I'm sure Chris has provided you with those.
Anything further?
That's it. Whether it's new trash or not, it's still a violation. We've got nothing further to add.
Is there anything else you would like to tell me?
No, ma'am, but I mean, if I go out there and you ask me to do A, B, C, D, and E to comply with my first appearance here before this court, and I do A, B, C, and D, and E, and then you go out at a later date and find E, F, G, H, and I, or whatever, I'm not sure how the clock starts back at A, B, C, and D. I mean, if I've done what you've asked me to do prior to this court's order, and I wasn't called in here for a second hearing, why would I be responsible for E, F, G, H, and I? Not that I wouldn't be totally responsible for it. I think I'd be responsible on a second level.
City, were there additional violations added after the original order was in?
No, the original order was trash and debris and outdoor storage. He went out there, he found things stored outside, and he found trash and debris. It's still a violation. We don't recite in that. There's nothing in Chapter 162, our city code, that we're required to recite again for the same violation that we're re-inspecting on. Additionally, I'd remind the magistrate, 13 cases under his ownership, so we've been managing the property and telling him what he needs to clean up for years.
So of those 13 citations, sir,
Okay.
would you mind, am I able to?
Yes, you're allowed to ask me a question.
Of those 13 citations, what would they all be? Do you have those listed?
I can look them up if need be. We've never had to do that before.
I'm not aware of that. I had 13 violations out there. I've talked to Chris Thompson maybe twice before this. If we can look him up, it might be just trash in front of the house, but I can't stand in front of the house and watch people put trash in a curb.
Well, this is what I'm hearing, and I'm a third independent party. That's
Yes,
why
ma'am.
they have the
I
special
understand that.
magistrate. I think after this hearing, you must have other violations on other cases in the past at the property or on other properties that you own.
No, ma'am, I don't own any
They
other
were on
property.
this property. None of them are open at this time. They were all complied without going to a hearing.
And was it with this owner or the previous
Same
owner?
owner, this owner.
Okay, so you've been through this process before.
No, ma'am, he just said it never came to this point. They were complied for before it got to this point.
Okay,
And it was like Okay, there's a piece of garbage in your front curb.
You obviously have, let's be practical. Let me just step away from
Yes, ma'am.
what the reduction, you will be getting a reduction today.
Thank you, ma'am.
And I understand what you're saying. I understand what the city's saying, but you both have the same problem. You've got people dumping junk on your property. This is rental property, correct?
Yes, ma'am.
You need to find a solution so that you're not back here. Obviously, you want to be responsible for your property. This is the first time you've been through this whole process. You know, you have responded to previous citations and violations in the past in a timely fashion. You need to find a solution that's going to prevent you from having to come back here and have your time and your funds used in this manner. It's not the best for you or your business, so I'm not sure if the city has any recommendations or there's another agency that might be out there to help you, but you need to find a solution
Thank you, ma'am.
to keep neighbors and passerbyers from dumping trash. Obviously, they want you to go to the expense of removing and disposing of their white goods and other goods. And it's a convenient midnight flight for some of these people.
Yeah, I understand. You understand. I mean, you get
I
it.
think we all understand.
I mean, if you
And
look at
there's
the first
gotta
set
be
of
a
pictures that
practical
Mr. Posner has,
solution for you.
there's like a table and chairs on the curb, and then you go back the second time, there's an air conditioning unit laying on the curb. It's like, I can't sit there. I live in Palm Beach Gardens. I've been a member of the Planning and Zoning Commission for the City of Palm Beach Gardens for 18 years. So I understand what it's like to be in these chambers and be on that side of the dais. So I understand your position, and I appreciate anything you can do for me. But I can't stand in front of the yard with an armed guard and keep people from putting stuff on the curb and driving away.
You
It
need
just
to-
happens.
Yeah, I mean, maybe your tenant, I don't know, this is just out of the box, but, you know, maybe your tenants can let you know, and maybe there's something that you can use to, that's natural landscaping
Yes,
that can help limit the issue, and, you know, make sure your tenant knows the days that certain parts of trash, if it's a vegetation pickup day, if it's just household
Debris.
or if it's a white good day, and maybe your tenant can work with you a little bit on it.
Thank you very much.
Okay, so with that said, this was a problem, and all property owners, especially with rental properties in this day and time, have an issue of recurring problems that you fix it one day and then the next it happens again, and it's just the responsibility of the landlord at the end of the day. I understand your parameters and what you're working with. So what I am going to do is I'm going to reduce it down to $1,500.
Thank you.
And how many days do you need to pay?
I can write a check today, or say 30 days.
We'll say 30 days.
Yes, ma'am. Thank you.
Thank you, and
Mr. Posner, thank you, sir.
I
Like I
hope-
said, he and Officer Thompson have been gentlemen. They've been great.
Yeah, they are very good, and, you know, we hope we don't see you again.
Thank you.
Yep, you need a solution. You need a practical solution. The legal solutions are not always the best.
All right, thank you.
Yep.
And lastly, number 3, 629 58th Street, CE 19040547, number 3, 629 58th Street.
Hello,
Hello, and your name for the record?
Shanika Green.
Say that one more time.
Shanika Green.
Shanique Okri?
Yeah, Shanika Green. Is the
Okay.
color green?
We're going to have the city speak first, and then we'll come and you can say whatever you need to tell us.
No problem.
Thank you.
You're welcome.
Case ending in 547, 629 58th Street, date ordered 6/19 of 19. Fine started 7/22 of 19, ran for 60 days, total $6,000. $100 a day, data compliance 9/20 of 19. The only mitigation is it was caused by their tenants. Fines ran for window screens, address characters, and bare landscape. Also cited for storage and outdoor storage and junk vehicle, which was complied before the fine started. City's asking for 30%, same owner.
Thank you. Okay. What would you like to tell us today?
Yeah, so first off, the reason why I found out that there was a lien on the property was because I was trying to get a refinance on my property, and the title company actually did the search. So with those, the amount that was for the lien, immediately, did what I could to fix the issue, as well as Mr. Robert Wickens. He was working, with me to let me know what that need to be done and what I need to do to get the fine reduced. Actually, I have problems with my mail, so if I do get a notice, I don't get it. Because when my mails come to the house, the tenant in the front or the one in the back, I think maybe they're thinking that they're doing something good by collecting it for me, but I don't get it. And as well as my taxes and other information. So I have those information routed to my father's house, so I can, as my mailing address. These issues with the grass, the tenants, I tell them, don't park on the lawn. They don't do it when I'm home because I also live at the property. So they don't do it when I'm there, and when I'm at work, their friends come or whoever come and they will park it on the grass. So the grass, had a spot there, and it found out that it was an issue because of the, after doing the lien search and finding out that there was, the liens that were occurring, I immediately fixed it. The screen on the top at the second floor, I had to get somebody to put those in. So we had the screens, it just fell out from the window. The debris, when they said, if you see the picture there, the debris was just a few boards at the side. That I immediately, picked up myself.
Okay.
So I immediately, came to the city, done the lien reduction, paid my $200. Also found that there was an open permit. I had to go through all the steps needed to clear that out with the title company and so on. So I'm just asking for mercy and to for this $6,000 lien.
Okay. Anything else from the city?
No, ma'am, nothing to add.
Actually, on my lunch break from work, I get paid $12 an hour, and this property is what helps to pay the mortgage. So that's the reason why I was even trying to get like a refinance to lower my mortgage payment.
And sir, was this the same owner at the time the violations were cited?
Yes, ma'am.
Okay. Is there anything else you would like to add?
No, this is, knowing that, I have to be on top of the tenants, which I have given them a written notice about this issue, and I let them know that, listen, because of the parking of the grass, the vehicle on the grass, this is something that I have to now get to the city to sort the matter out. And the property of, every paycheck I put aside and to, do the painting and so on. So thanks to Mr. Robert, actually, and Miss Williams, working with me to, get things done accordingly. So I'm just really asking for, to waiver the fees if it's possible.
City, do you have anything else?
No, ma'am.
Okay. Okay, this is what we're going to do. We're going to reduce it down to $1,000. That's going to take care of most of the city's administration costs and maybe a little bit of the fines, but probably it's just really the administration cost
Okay.
for the most part. How many days do you need?
Is it possible to get 90 days?
Yes, it is.
Thank you.
You can come and pick up your order and just keep on top of your tenants and don't
Thank
let them
you.
get you back in here again.
That's it, right?
As far as I know.
Thank you so much.
Do I need to close the hearing? Yeah.
You can adjourn it.
We can adjourn the hearing.
There's some wacky ones today. Huh?